Hello and welcome to today's webinar. Today's discussion is all about neighbor issues. My name is Paula Price. I'm with the People's Law School and I will be your host and moderator for today's webinar. Now, we are thrilled to be joined by Craig Watson. I will introduce him in just a few minutes. And we are also delighted that this webinar is produced in collaboration with the Blockwatch Society of BC. I'll share a few more words about that in just a moment. Now, if you have questions about neighbor issues, you're in the right place. As I mentioned a moment ago, we will be talking about fences, trees, property nuisance, parking, and dealing with conflict. And if you missed the earlier webinar where we talked about noise, dogs, smoke, difficult neighbors, privacy, reputation, and when to involve the police, you're welcome to check out the recording on the People's Law School website. What you can expect today, we've got about 60 minutes together. We will be providing answers to common questions. It is legal information, not advice, and it's current as of today. If what you're looking for is legal advice, in other words, the law, as it applies to your unique set of circumstances, we encourage you to reach out to a lawyer. You are welcome to reach out to our speaker, Craig Watson, at the contact information on this slide. And if what you'd like is to learn more about the Blockwatch Society, we encourage you to go to the blockwatch.com website where you can learn more about your local program. We are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose people continue to live on and care for these lands. And we encourage everybody who is joining us here today to reflect upon where it is that they are joining us from as well. We would like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support has made it possible for us to produce these webinars for you. And finally, we would love to welcome and thank our speaker, Craig Watson. Craig is a lawyer and principal of the Meridian Law Group. Craig is a trial lawyer, and he has been a trial lawyer for nearly 30 years. And he has experience helping his clients with disputes of all natures, including neighbor disputes, trespass, and land use. So, Craig, thank you so much for joining us here. We are thrilled to have you here today.
Thank you, Paula. Appreciate it. I'm glad to be here.
Wonderful. So, we are going to jump into our first question, which is the fence between our property and the one next door is literally falling apart. I tried talking to my very hostile neighbor, and their reply was unprintable. Can I replace the fence unilaterally? And will I have to bear the full cost if I do?
So, similar to most answers that you will get from a lawyer, the answer is it depends. Fences, the law on fences has developed over hundreds of years. Can you replace the fence unilaterally? Depends upon where the fence is actually located. Is it on your property, on your neighbor's property, or right on the property line? If it's on your property, it's technically your property, your fence, you can replace it at your cost, and you can do it unilaterally. If it's on your neighbor's property, you cannot replace it because it's on their property. And if you were to go on to the property to remove and replace the fence, you would be trespassing. If it's on the property line, it's what's called a shared fence. You each have responsibility for its maintenance and its upkeep, and you can then go and replace it. Best, though, to have that discussion with your neighbor, even though they're hostile, put it in writing. What I tell people is to be surgical in these sorts of emails. Don't put in, or these sorts of correspondence, don't put in emotions. Just, I try to talk to you about replacing the fence that's falling down. You didn't want to talk. I'm going to do it on such and such a date, and we can deal with costs later, or however you want to phrase that. You do, although, always on most of the questions I've seen, run into what lawyers would call an enforcement issue with the costs. You can send your neighbor a bill, they can ignore it. You will then have to go through, depending upon the costs of the repair, small claims court. or the CRT if it is less than $5,000.
Thank you very much, Craig. The next question that we have is, my next door neighbors did yard work a couple of years ago that damaged our shared fence. Are they legally required to pay for the fence to be repaired or replaced?
Once similar, there's a similar theme to some of these. The repairing, if it is an actual shared fence, meaning legally, meaning it's on the property line itself, then each of you are responsible for its upkeep and its maintenance. If their negligence damaged the fence, there you have a claim against them for replacement costs. Once again, though, if they're not taking steps to repair the fence and replace the fence, and you want it actually done because it's dangerous or an eyesore or falling down, you can do that. Take that step and repair it. There is, in terms of negligence claims, though, for damage to personal and real estate uh, property in general, in BC, a 2-year limitations defense. If you don't start a claim within 2 years, your right to do so is lost completely. So there is a timing issue always in terms of seeking reimbursement for negligence and damage to property.
Excellent. Thank you so much, Craig. We have another question here. Um, with the fence, how do I resolve a property line issue with my neighbor when they won't acknowledge that their fence infringes onto my property?
So this is one of these examples where the tall fences don't make good neighbors. And I see this type of claim often, believe it or not. Uh, where people are being reasonable and talking to each other, you could simply track a line between the two property pins that should be observable on the property. If, though, your neighbor is refusing to acknowledge that, the only way to set and deal with the dispute and identify the property line itself is to retain and hire a BC land surveyor to prepare a legal survey, which would be under seal, would be essentially conclusive proof of the property line.
Excellent. Thank you very much. And moving on to the next question, then. This is our last question about fences. My neighbor put nails along the top of our shared fence to protect against wildlife. I worry that somebody will get injured. What can I do?
This one's somewhat difficult. It depends on a number of issues. The type of the wildlife is problematic. If it's squirrels, as a sort of a facetious example, then there's not really anything to be too concerned about. I think, and you might need to look at what's been done from your neighbor's perspective, what they've done. I think the first point of review is the bylaws applicable to fences in your municipality. They're all somewhat similar, but there's nuances and differences depending upon where you live. An example, of course, as an example, the city of Vancouver sets out what fences, heights of fences and locations in general, but specifically prohibits barbed wire, razor wire, or electrified fences. Nails on the top of the fence, I'm looking at the screenshot, would not be covered under that sort of a bylaw restriction. One option then, regardless of the bylaw, if you're concerned, is to report it to bylaw enforcement and let them review it and determine if the bylaw itself is being infringed. Otherwise, depending upon where, once again, where the fence is located with respect to the property line, you can remove them yourself if it's on your side of the property. If it's directly on the property line, so a shared fence, as the law would define it, then the two of you are responsible for its upkeep and and injuries which might flow from it. So you could remove it. I would caution though about doing anything unilaterally or without putting some sort of advance notice on your neighbor, um, in terms of the self-help type remedies, something in writing saying, I'm concerned, this is why I'm concerned, this is what I propose to do. I'm going to do it unless you tell me otherwise, would be advisable, because otherwise you're going to look at an escalation if you don't take some reasonable steps to set out the scope of the work that you're talking about.
Excellent. Thank you so much, Craig. That wraps up our questions about the fences, and
Mm.
we're moving now into trees and shrubs and that sort of thing. So here we have a question. Our neighbor cut shrubs and trees on our property without permission and damaged them. When I tried to talk to them about it, they ran away. What can I do?
Well, it depends. Once trees and shrubs, your neighbor trespassed. If the trees and the shrubs are on your side of the property line, and there was no consent to allow the neighbor to come onto your property and cut the trees or remove the shrubs, that's an actionable trespass. Uh, the issue, though, in terms, I'm not sure with the question if it's what can I do about replacing the vegetation, or if it's concern about future trespasses. If it's fixing and replacing the vegetation, similar steps are as with what we talked about, the fences. You can obviously write your neighbor, since they're running away and not wanting to talk about what they've done. Set out your concerns about the breach, the trespass, sorry, and the destruction of your property, and that you expect them to reimburse you for the costs of replacing the trees and the shrubbery. Otherwise, if there's no response to that, your option, unfortunately, is to bring a claim for the costs of replacing the trees and the shrubs. That would be the success of that is going to be dependent upon the type of evidence and the reasonableness of the costs of replacing them. Um, the court will, not replace like order recovery like for like. If you had a 200-year tree that was cut down, as an example, you're not going to get the cost of a replacement for that 200-year-old tree, but damages in addition to the recovery or the replacement costs would be allowed. If you're worried about continued trespass, once again, I would a letter. I don't know that I would send a letter worrying about trespass, although a demand letter saying don't trespass on my property is generally a good first step. Security cameras many people put up to provide some comfort. You need to be careful though about security cameras, because it raises the potential for a claim against you if you're focusing those cameras on your neighbor's property as opposed to simply your property.
Thank you so much, Craig. Um, and just a note for everybody who's watching, there are pages on the People's Law School website where there are sample letters and templates and things. So that might help to gain some ideas about how to write these letters to your neighbors. Um, and Craig has mentioned the CRT. We will be having a webinar in a few months' time about the CRT process if that's something that becomes unavoidable for your neighbor disputes. So, moving to our next question, where we're talking about trees. In this case, our neighbor has a large tree whose trunk is on their property. If the tree falls and damages our property, or if the tree's branches damage our property, who is responsible? And would it be different if the tree trunk was partially on our property?
So, in answer to both parts of the question here, the first thing I would raise for everyone is to be mindful of homeowners insurance. If you have homeowners insurance and a tree falls, the insurer If the claim is within coverage, we'll pay for the repairs to the property, to the house, if it damages your house, or to your car, or a friend's car that's parked in the driveway. If someone, God forbid, is injured because a limb or the tree falls on them, homeowners insurance will respond to that as long as steps haven't been taken which would breach the coverage. So that's the first thing I would, you know, highlight in this sort of fact scenario. Homeowners insurance is there. Presumably, excuse me, presumably you have it and you purchased it for exactly this sort of reason. So, second, on terms of the property, the tree is on their side of the fence, clearly on their um, property. They are responsible in the first instance if uh, the tree falls or branches fall and damages a property or it hurts someone. There's an obligation on landowners to maintain um, trees. It goes back for, it's a common law obligation. It goes back for a couple hundred years, a number of hundreds of years. If the branches are coming across onto your property, this is touched on a little later, and I'll deal with it a bit more. You have the ability to um, maintain what's coming onto your property, but that's a question that's coming up later. Now, if the trunk is partially on your side and the other side, your property and their property, um, it does make a difference, but unfortunately, the law is not clear on that. Although the common law is not clear because it depends where it was planted, how long has it been growing, and how far over the property line and whatnot it is. But I think from the common law's perspective, the key takeaway is if it's straddling the property line, you each have a shared or joint responsibility to maintain the tree and keep it healthy. The last caveat to all of what I've just said is that municipalities have very stringent tree bylaws. You cannot cut down a tree unless you get a permit, and there are significant fines that flow from it if you do, depending on how many trees you're cutting down and how often you've been guilty of ignoring the bylaws. Some of the municipal tree bylaws also impose um, maintenance obligations and who can and can't do what I've called maintenance, basically trimming and whatnot of the tree so that the tree isn't damaged or die. So that would be something else you would need to take a look at and satisfy yourself about.
Thank you, Craig. So, moving on to our next question. In our neighbor's yard, a tree has branches that are overhanging onto our property. They are not doing the upkeep. Can I trim the branches without their permission? And if not, what can be done?
One of the simplest answers you're going to ever get from a lawyer, perhaps, is yes, you can trim the branches without their permission. Now it gets more difficult with a couple caveats. One, only on your side of the property line. Two, not so far into the splits, the stem of the tree, so the trunk of the tree, that it might damage or kill the tree. Three, relevant city bylaws on tree, uh, we'll call it tree maintenance, may be applicable and have some restrictions on what you can do. But from a common law perspective, you can, trim back the branches on your side, so long as you don't damage the health of the tree. Might be best if it's a significant tree, a large tree, an old tree, to get an arborist or in to take care of that. Now, in terms of all of these sorts of neighbor complaints, trespass is a real concern. So you cannot go onto your neighbor's property to do the maintenance. You have to take care of it entirely from your side of the property line, and otherwise you might well be sued for trespass.
Thank you very much. Moving on to the next question. My neighbor recently planted two large fir trees within 2 feet of our property line and 6 feet of our house. Is there anything I can do about it?
So this one is entirely dependent upon the applicable municipal bylaws. You can plant a tree at common law, so without zoning and restrictions or city use restrictions. You can plant trees on your property. Setback restrictions in city bylaws and planning typically apply only to buildings or structures, not to trees or hedges. Um, it's unfortunate, but that's uh, the lay of the lay of the land on this one.
Excellent. Thank you very much, Craig. I will say you're very efficient in answering these questions. Great.
I thought I might be going a little too fast, so I'll talk much more slowly if that will
Whatever,
help.
whatever pace works best for you. It'll leave us more time for questions at the end. So
Okay.
that's great. This is our last question about trees. A tree on our neighbor's yard is growing into our shared. Well, now we're actually blending the trees and the fences. Our neighbor's yard, sorry, a tree on our neighbor's yard is growing into our shared fence and damaging it. Is it our neighbor's responsibility to pay for the repairs or replace um, the fence, or is it a shared expense?
So there's a few issues with this question. Shared fence, we've touched on this a bit already. That's got a distinct meaning for the courts and lawyers. It's not a fence in between two people's yards. It's a fence that is actually on the property line itself. Um, so the second is the tree and where it was planted, how big it is, how old it is, and the root structure. And the third would be which was there first and which was built around it. If the tree was planted after the fence and simply was planted too close and grew into the fence, then yes, I think it is in the first instance your neighbor's responsibility to repair the fence. Although if it is an actual shared fence along the property line, you can do so as well. The costing issue, which is something that comes up with all of these sorts of disputes or conflicts. It's one thing for someone like me to say, yes, your neighbor's responsible for the cost and for paying it, but that's unfortunately why people like me are around, because someone might have a legal obligation to pay for damage and then refuses to do it. And then you have to go to court to enforce your right and sue for that repayment, or sue to get an injunction to force your neighbor to repair the fence, which would be less likely than simply you fixing the fence and seeking recovery of the costs. Once again, fixing the fence, regardless of who is responsible for it and who takes those steps. There's issues of trespass. You can't go onto your neighbor's property to fix the fence, and they can't come onto yours. So this is a sort of neighbor dispute, where your best caution to try and work it out between the two of you and make it work as seamlessly or as frictionlessly as possible. But that's generally not the situation when we're having these sorts of discussions.
Excellent. Thank you. And Craig, for my benefit, I'm sorry,
Yeah.
when you were talking about which comes first, the tree or the fence, and
Yeah.
you were mentioning that will affect whether or not the neighbor is responsible. So if the tree is already there and then the fence comes next.
If the fence is built up around the tree, it's going to depend on a bit of a historical, sorry, from a from pursuing a claim in a court with evidence is going to have, so the historical background is going to have some bearing on who's responsible for repairing the fence. If the tree was there first and was on the or straddling or close to the property line, and the fence was built up around the tree, if the person who built the fence is shown to have known that the tree was going to damage the fence within a reasonable amount of time, then that's going to weigh, uh, to my in my opinion, heavily on the court in determining who's responsible for the damaged fence. You can't build something in a place where you know it's going to be damaged, and I'm going to be facetious, in 3 weeks, and then expect somebody to pay you for the costs because it was damaged.
Thank you so much for clarifying. So moving away from fences and the trees, in this situation, we have a neighbor who parks boats, RVs, campers, giant tarps on them in their carport for months at a time. It is an eyesore, and the neighbors are wondering, is there anything we can do about it?
Yes, there absolutely is. Believe I've had disputes like this in the past. The primary source of satisfaction, I'll call it, is going to be through the your municipal bylaws. Most municipalities have bylaws which deal with derelict sort of situations. So the front yard that has multiple cars. There are bylaws that prohibit that in most, if not all municipalities and jurisdictions. Report it to the, and I'm assuming that your neighbors are not inclined to have discussions and move the RVs and the boats and the campers off of the front yard or the carport, or put them in a place that's less offensive to the neighborhood. Um, Report it to by law enforcement, and they would then take over. Now, one issue, of course, whenever you report to bylaw enforcement in your municipality, is that you should assume that your neighbor is going to find out that you were the one who made the complaint. It's never a safe practice to assume that there's anonymity, or that you can you do something, make a complaint about someone in confidence, particularly, if the bylaw enforcement lays charges under the relevant offense act, or the bylaw, and there is some sort of court proceeding to enforce the bylaw. You then become a witness. Your name and the complaint that you've made to the municipality is produced in full to that other person's lawyer, so that they can prepare for and defend themselves, in court.
Thank you, Craig. And just following up on that question, then, if you were to report to your municipality, you mentioned the other side would potentially have a lawyer representing them in that regard. Would you, as the neighbor, also be required to have a lawyer with you, or what does that process look like?
No, the bylaw enforcement. Well, as an example, at one, I bought one bylaw enforcement from my past. I acted for an arborist who mistook which trees to cut down on a new construction site. So he and the owner of the site were prosecuted by the city under their tree bylaw. Uh, the person who made the complaint, is similar to a criminal process. You make the complaint, it then goes to Crown. In this instance, the city's bylaw enforcement lawyers, and they take over. As the complainant, you are simply a witness moving forward. You have no control on the bylaw enforcement proceedings at all.
Excellent. Thank you so much for clarifying, Craig. And I appreciate that a number of the questions that we've posed so far, one of the resources that is available to the neighbors who have the issue on their hands is potentially that their municipality will effectively help them out in dealing with these concerns. So thank you for sharing that with us and also explaining the process a bit more for us. Um, Moving on to another situation here, our neighbor's abandoned garage is infested with raccoons. The raccoons cross over onto our property at times. How can we deal with this?
So this is a health and potentially life safety concern in addition to simply a pest, an infested garage. I think living in the Lower Mainland, as I do, many of the people on the seminar do, raccoons are everywhere, and they can become quite quite large and uh, territorial. So this was one where there are most certainly bylaws, and there are enforcement requirements and mechanisms in place for this. I believe every municipality has something comparable or comparable to animal control or pest control. You should phone them through the municipality, and they will then deal with this. They will come out, they will assess, and they will, how do I, remove or deal with the raccoons and the problems that will that result from it. This sort of issue has come up. I've seen it in terms of hoarders, people whose garages have everything left in them and brings in not raccoons. This is the case I dealt with a little back a while ago, but rats and mice, which were getting into neighbors in a strata complex's property, and the strata was unable to deal with it. Uh, Pest control, animal control was brought in through a complaint by the strata in that instance, and they were the animals were removed, and the underlying problem being the hoarding was dealt with through the bylaw enforcement. Strata versus detached homes isn't going to change that um, analysis and that result.
Excellent. Thank you very much, Craig.
So sorry if I could just one
Oh,
last
please.
on
Yes,
that last picture, last slide.
absolutely.
If you don't get appropriate satisfaction results from bylaw control or animal control, this is a claim potentially a nuisance as well, although the court system would take longer to deal with removing the pests and the raccoons coming over your property line in terms of injunctions, but um, it's always an option if the on this type of a situation if animal control and bylaw enforcement doesn't deal with things quickly.
Excellent. And just in terms of timelines, you mentioned, practically speaking, probably not a very quick response. What do you estimate a timeline would be for that?
For well, bylaw enforcement is a phone call, and then they, possibly three or four more, because they're busy people and they don't typically get out right away, and the squeaky wheel does get the grease. Court proceedings can be, well, they are more costly to you because it's not simply a phone call, and then there's the time frame includes preparing the evidence that's needed because on that the prior example, affidavits from you, potentially from others who have witnessed the problem and the effect of it on you. You then have to serve the other side, and the court rules require a certain amount of time for them to respond depending upon the type of proceeding and where they live where they are when they're served in BC, out of the country, things like that. You are looking at a couple at the earliest months, a few months, unless there's a basis for um, uh, without notice application, which can be done as soon as a judge is available and the materials after the materials are prepared.
Thank you very much, Craig. Moving on to this next question. To paint the exterior of my home or fix my gutters, I need to place a ladder on my neighbor's property, but they refuse to let me. Is there anything I can do about it?
This is an unfortunate situation. Neighbors don't have to be neighborly, and there's Court of Appeal decisions which say that a neighbor can refuse to let someone come onto their property for any reason whatsoever, and it doesn't matter. So, in terms of what can I do about it, assuming that your neighbors are going or don't understand reason or listen to reason or care about your safety to be able to clean your gutters and or paint the side of your house or anything else. Um, Depending upon the neighborhood who built the houses, the developer, there may, although it's unlikely, be an easement registered against title to allow for maintenance. Some developers now are setting up neighborhood. The name now escapes me, of course, but basically uh, uniform neighborhood requirements that allow for maintenance of the property, to have all the houses look similar, things that can't be done in the development and whatnot. And older developments, when I say older, I mean like 100 odd years ago, would have the similar sort of um, requirements. So that might be there. The other option is there may be some, once again, bylaw, although on this particular question, I would doubt that there would be something allowing a homeowner to trespass onto someone else's property to maintain their own property, because that is essentially what you're asking to do if there's no consent, is to trespass onto the property. The third and most costly option is to commence proceedings in the Supreme Court of BC to seek an easement or a limited right of access to maintain your property, but that seems grossly time-consuming and costly for something that um, seems to be one of those things that should happen in just urban settings where we're all living cheek to jowl, as it were.
Yeah. Thank you very much, Craig. Sort of tough, tough position to be in.
It's unfortunate. You can't simply go onto someone else's property if they say no.
Yeah. And to find that easement, I imagine, what would you do? A title search of your neighbor's property? How would you?
You could do a BC Online search of the property. BC Online is the outfit that does the title searches for land titles. The last time I checked, I usually just ask someone to do that for me. If you don't, you wouldn't know um, the what's called a property identify PID, property identifying number document, but you can do a double search through BC assessment on the address, which will give you the PID, which would then allow you to do the BC online or land title search to see if there's easements granted. I would do it on your own property and their property to see if there's any sort of connection.
Excellent. Thank you so much. It's really great information. Um, Moving on, so we've now kind of talked about the access to your neighbor's property, and we're diving into parking and lots of questions about parking. So here's one. Who has the right to park outside of your home? And can you put a sign outside your home saying family parking only?
I'm going to assume for this question that we're talking about a city street, and not a private street. Um, there aren't a lot of private streets in urban areas. They're more rural than not. So in a city, assuming it's a not a private street, which is a safe assumption, everybody and anybody has the right to park outside your home because the city street is owned by the city and not you. Um, Now, that doesn't mean that someone can park their car and stay there forever, but the you have no ability to limit or stop, no legal ability or right to limit or stop people from parking in front of your house. You can put a sign up, but it's has no legal effect, and it has no ramifications if someone is ignores it, or other things we all see are pylons being put in front of someone's house so that you can um, maintain your parking spot. If you're thinking about putting a sign up there, I would be a little bit more uh, demonstrative. Something like this spot helps an elderly resident get to their home rather than just family parking only. You have to play a little bit on sympathies of whomever might be parking there. But absent city bylaws, which limit parking to permit only, anyone can park anywhere.
Excellent. Thank you so much, Craig. And I love that suggestion as well. I can see that being helpful too if you're trying to reserve a spot for moving, for example, and you've got your cones up. I see this in my neighborhood to
Yeah.
explain what it is that you're doing. That's great. Here's another question about parking. What should I do if my neighbor won't let me park my car in front of her house, even though it's legal for me to do so?
Well, there's it is legal for you to do so. This is part two of the previous question. Um, uh, I guess it depends on what the neighbor is doing. If it's a pylon and there's no reason for the pylon, you just heard me say you can pick the pylon up and move it. Those sorts of actions escalate tensions between neighbors and cause problems later on. Um, I'm not sure that bylaw enforcement would have any role in this, but they might, depending on the municipality you live in, and if there is a specific bylaw for street parking. Otherwise, I think you're really dealing, unfortunately, with a hostile neighbor who has no right to do what they're doing, and any escalation could well get you and them into more difficulties with a civil or you know the worst case scenario, criminal type involvement. This is a tough one. This is a quintessential um, non-printable next door neighbor issue.
It is difficult, and I think that really strikes at the heart of some of these neighbor issues too, right? Is that close proximity, and these are people who you live very close to. So managing the relationships obviously is part of the challenge. This next question, Greg, how long can people park on the street without moving their vehicle?
Every bylaw, city bylaw has some sort of restriction or indication of this. There's no set um, time limit or requirement. I People park their cars, go into their house, and stay in the house potentially for a number of days before they have to use their car again. So there's no real hard and fast rule. If you think a car is abandoned, you can phone the RCMP to have them come and take a look at it and deal with it. Um, if you think there's other issues at play, the RCMP or the um, bylaw enforcement can be involved as well. And I just saw something in the chat come up that North Vancouver, it's 72 hours the cars have to be moved. So once again, it depends on the city and the bylaw that's in place. I wouldn't 72 hours in that example. If your phone is 72 hours to complain, they'll probably take another day or two to get out there, but at least you have that mechanism. The issue then becomes where does the car go? Somebody might well just come out and move it half a car length forward, right?
Exactly. Thank you. So the answer to go, the place
Yeah.
to go, the answer really would be to check with your municipality and see what
And
the
this is exactly, and this is assuming there's no street sign up there limiting parking. This is assuming that this is just uh, uh, a street in a suburban street with parking available on the curbside with no restrictions.
exactly. Thank you, Craig. This is our last parking question, and it is: who is responsible for enforcing parking regulations in my neighborhood? Is it the police, the city, or another entity?
In the first instance, it's going to be the city bylaw enforcement, the city bylaw ticketing officer. I've been down in Steeston as an example, and I'm during the summer, and there's a city bylaw um, car that's driving around dropping parking tickets off um, with distressing frequency if you're trying to park your car. If it's more uh, serious, more problematic, or then the police would be involved, but they're not going to be giving tickets to people for parking in the wrong space, unless it's, as an example, a fire lane in the back alley. But even then, the first instance is going to be the city.
Excellent. Thank you so much, Craig. And we've got one last prepared question, and then we'll be turning to the live questions that came in today. And so this is really a catch-all or a question that would refer to a lot of the questions we've covered already today. What recommendations do you have for resolving conflict with your neighbors without necessarily escalating to the municipality or starting a lawsuit?
This is a hard one because I'm involved. My job is conflicts. Like, good neighbors make all of these issues easier to deal with and less prone to conflict. And by good neighbors, I mean um, so knowing the people you live around somewhat and talking to them, having some point of contact uh, beyond the dispute, and that's a paradigm, if you will, that takes a long time to develop. It's not right off the bat. Um, if you don't have that relationship that you can resolve, almost a friendship or friendly relationship, know your rights, but don't have conversations about the point of contention focused on on your rights and your demands right off the bat. Have a conversation with the person in general and just talk about why it is that something is a concern to you so that you can address the issue amicably between each other. It's almost like a mediation, if you will, from my perspective, where you're trying to come to a resolution. And no resolution ever happens, in my experience, if one side is focused on their rights and the other must comply with my rights or else. As soon as you get into that or else sort of a discussion, people's backs get up, get hackles get raised, and you're walking down the road towards litigation and a fight. If you continue to have the conversations, my view is to make it put it into writing so that there's a record if you do eventually need to get into some sort of dispute resolution, whether it's reporting it to the bylaw enforcement or going to court. Um, eh, Whether you go to bylaw enforcement or hire someone like me, you're going to need evidence and you're going to need more than simply, I think I remember 6 months ago, I asked them to do something. You're going to want something that shows what you did and how you asked it. So there's, the letters or that you send or you drop off to your neighbor about a dispute, as I've said in the past, should be surgical. It's the way I say it. Leave emotion out, leave demanding rights out. Just, I have this issue with your tree being not kept and the branches are going to fall onto my car. We need to come to an agreement on how we're going to maintain the tree so that my car doesn't get damaged. I think that it's your tree. You should be responsible for the costs at the very least, although I can, take care of the maintenance on my side, that sort of thing. And if there's disputes, keep a log, keep a diary. In your diary, you could be a little bit more explosive if it helps you maintain your anger management. But from there, be mindful that that might one day, in a legal dispute, become a document which is produced and the other side will see.
Excellent. Thank you so much, Craig. It's really, really practical information. So I'm turning to the live questions, and I'm going to read this first question to you. Our neighbor's property is sliding into our property, causing a hazardous situation. They refuse to have a retaining wall built. What can we do to protect our property from a landslide?
So This goes back to some of the answers to the fence and the fence questions. A retaining wall is a fence. It's and the owners of the other side have an obligation to maintain their property and not to cause damage to your property. So a common law, what you're describing there, the property slope instability and a slope failure, it sounds like a hill, one falling into your property. That would be what would be phrased a nuisance, and you could bring an action for an injunction requiring either that they build the retaining wall or reimburse you for the costs of building the retaining wall and allowing you to trespass onto their property to have the retaining wall built. Um, or the fallback, I think, on all of these sort of neighbor disputes in particularly urban settings is that building city bylaws may well deal with the issue, but I don't know. The last caveat or last consideration for that question, and as I'm thinking this through, is if there is a retaining wall already there and it's starting to fall down, that would strengthen the claim that they need to maintain the retaining wall and replace it. And if not, you need to take those steps because there's an issue of life and health safety.
Excellent. Thank you so much, Greg. Here's a question about statutes of limitation. Does the statute of limitations apply to property line issues? For example, if a structure such as a fence exists and has not been challenged for over 2 years, is there a loss of property or right to claim?
I do not believe there is. This is something that I've looked at a few times with matters, and the reason is that is it's a continuing um, infringement on the land and the trespass. The trespass, because that's what we're talking about. If a fence is on your property or if a building is on your property, it's a trespass. It's ongoing, and you have a right to bring an action under the Property Law Act to have the encroachment removed.
Excellent. Thank you.
The limitation period goes more to, in what the way I raised it, recovery of damages or costs.
Excellent. Thank you. Here's one that has received a lot of six upvotes, and it's about garbage bins. We live in a strata duplex, and down the lane is a series of row houses. The occupant of the row house continually brings his garbage and dumps it in our bin and or leaves larger items by our garbage can. We paid privately for garbage pickup, and he received city garbage pickup. We've caught him red-handed, and he just shrugs his shoulders and walks away when confronted. What can we do?
So I'm going to assume that the row houses down the road are also strata. So and you live in the strata duplex. Your strata council, which is the two, if it's simply a duplex, is the two of you, should send a complaint or a demand letter to the strata council or the property manager for the row houses, identifying the problem and demanding that they rectify it. And that's not simply that it's making this person stop, but to put in place the proper garbage disposal options that seem to be missing from the description that the question you've just given me. Otherwise, the garbage bins you have are in the back. They are in the alley. They're on public property, presumably. You should discuss with your um, contractor who you're paying for the garbage removal the option of locking the garbage bins.
Wanted to thank everybody for joining us here today. Craig, wanted to thank you for your very thoughtful answers and very practical answers to all the questions that we had today. A big thank you to the Blockwatch Society members who posed those questions initially, and a big thank you to everybody who is here today and who put their questions in the Q&A. A big thank you to the People's Law School team who is working behind the scenes to respond to those questions. And just a note for everybody as well that the People's Law School website has some really excellent resources when it comes to, well, on a lot of different topics, but in particular for neighbors in terms of questions that you might have and suggestions for templates, letters, how to approach your neighbors. So you're welcome to check those resources out as well. I would love to ask Craig, and again, Craig, thank you so much. You've done such a fabulous job of responding to these questions. Is there anything that maybe we didn't cover today or that you would like to highlight in terms of today's discussion about neighbor issues?
A lot of these issues for neighbors, neighborly um, living, if I will, is simply can be avoided, I think, if you know the people and try to talk to the people. You don't have to be friends with them, but just know them and have some sort of more conversations when you see them. The second sort of common theme is what I would call enforcement. And your rights are only as good as the remedy is something that people like I say often. And to enforce your rights, you got to take unfortunately time and money to do so. So the only people who like courthouses are people like me. So if you can maintain some somewhat amicable or pleasant relations with the people who live on both sides of you, so much the better.
Excellent. Such great ideas to conclude with today. 100%, right? Is keeping up those relationships with your neighbors so that you can avoid finding yourself in a situation where you do need to take recourse through a court proceeding or some other fashion. So with that, we will wrap up today's webinar. We look forward to seeing you at our next webinar. Thank you and have a wonderful rest of your week. Bye for now.
Thank you.